Thank you for joining us today. We're very excited to be here to present Getting Your Startup Ready for Fundraising, What You Need to Know. We want to thank Twin Cities Startup Week for inviting us to be part of its program for the EdTech track. And we'll get started here. Wanted to let you know that we will be answering questions after the presentation. So please feel free to leave any questions you have or type them into the chat box, and then we will try to get to those after the presentation is concluded. Okay, to start out, my name is Patrice Kloss. I am a partner at Fox Rothschild, a national law firm. I've been practicing law for about 23 years, and I regularly represent emerging companies, venture capitalists, and strategic investors in debt and equity financings. Beside me is my colleague, Kathryn Dehn. Kathryn, can you tell people about you?
Yeah, I'm Kathryn Dehn. I'm an attorney at corporate attorney at Fox Rothschild with Patrice, and I help companies all the way from startup to their exit. So whether that's a merger, acquisition, or an IPO, and everything in between. I spend a lot of my time doing financings and capital raising.
And then for a venture capital perspective, we have Lisa Crump with us. Lisa, can you tell the audience a little bit about yourself?
Yeah, thanks Patrice and Kathryn. It's a pleasure to join you on this presentation. I've been on both sides for multiple companies and have exited, and am now an investor. I have my own investment arm called Karen Ventures, and I'm also a managing partner with my other colleagues with Sophia Fund.
Oh, do you need?
Okay, I just lost everything.
Oh, really? Okay.
I don't. Sorry.
That's okay. You seemed fine to us. So did you just you just lost it on your screen?
Yeah, nothing's showing up. I'm not sure what happened.
You hold it together, though, Lisa.
Yeah. Did your computer fall asleep or?
Am I that boring?
No.
Huh. Okay, now you're there. I apologize. I have no idea what happened.
I wonder if like your computer fell asleep or kind of the screensaver came on. So
not like that usually, but anyway. Okay. I guess we're going to edit that last part, huh?
Yeah, we'll edit just those last few seconds. And if you want to start whatever you were saying over again.
Okay, great. Well, thanks, Patrice and Kathryn. It's a pleasure to join you on today's presentation. I'm actually a person who's been on both sides of the table, both on the ask side with several companies, and I've gone out for fundraising. And then I'm also now an investor because I've exited several companies. So I do understand what you might be going through for those of you who are looking at fundraising. The investment arm that I have is called Karen Ventures. And then I'm also a partner for other managing partners, and we invest in diverse-led teams with tech-enabled high-growth opportunities. And we invest between 100 and 500,000 in a company. Some of the companies include local companies, Citizen, a peer-to-peer marketplace, Abilitech, which is a wheelchair for the arms, Clinician Nexus, which automates processes for rotation, medical rotations, and Oculogica, which is a concussion diagnostic device aid. And that's how I got connected with Patrice to begin with, was through that investment. So it's a pleasure to be here.
Thanks, Lisa. So we'll get our discussion started. We got our first slide. So here, the theme here is what you need to do to get ready for a financing. And the one thing that we want everyone, as attorneys and as investors to be aware of is that you want to make, as a company, you want to make yourself as attractive as possible to other investors. In doing that, you want to make sure that that there's nothing about your company that would be perceived as a problem by investors, in the sense of having any of the things that we're going to talk about that would make them think, that investor think that it would need to be fixed, or that they think that they should stay away from you because of that. So really the purpose of this presentation is to help you know the things that they'll be looked at, and so that you can have that ready to go. Always be aware that although some things can be fixed, you may not be given an opportunity to fix things that are found, and you want to make sure that you have a good picture and you put a good face forward on your first interaction with any investor. So with that, we'll go to the next slide.
Great. Thanks, Patrice. So as a founder, one of the initial decisions that you have to make is if you're going to organize your company as an LLC or a C Corp. So as an initial matter, VCs typically will only invest in C Corp. So if you're intending to take money from venture capital firms at any point during your growth as an organization, then you'll want to organize as a C Corp. And that's primarily because while LLCs get some favorable tax treatment, they're significantly more complicated to manage and for investors to get money out of once they have a lot of members or a lot of investors. So in most VC firms also may have reasons that they're unable to invest in LLCs. So LLCs can be really good for smaller companies or for companies that don't intend to take on a lot of investors, but C Corps are definitely the way to go if you have a plan to exit, like an IPO or a merger acquisition at the end. And you can convert, if you're already an LLC, you can convert from an LLC to a C Corp. It's not it's not too complicated of a process, but it's increasingly complicated the further along you are in the development. So if you're still a pretty early stage company, with the help of an attorney, you can convert from an LLC to a C Corp, but the later you go, the more difficult it gets to convert.
All right, next, invention assignments. Here I want to just make clear that an investor will expect that any intellectual property that's been invented by your founders is held by the company and not your founders as individuals. So you will want to make sure that you've signed appropriate invention assignments between your founders and the company, assigning any sort of IP that the founders are bringing to the table when forming the company to the company, so that the company is the owner of that IP. Sometimes people think that the founder can continue to own the IP and maybe license it to the company. That's not something that generally works for investors. So just, there are particular situations where that might be a case, but for most of the time, you really want to make sure that the IP rests with the company. In addition, you want to make sure that all employees that you have who are working on the inventions of the company or the products of the company or anything like that have signed invention assignment agreements in favor of the company. And those, you want to make sure those go in place at the time of hiring and not afterwards. So those are things that the investors will routinely look at and will want to make sure that that's properly done. And it's much easier to have those in place when you're beginning a company than trying to get signatures later on when people might have left and moved on.
Similar to invention rights agreements, confidentiality agreements, you'll also want to get in place with all employees, consultants, service providers who may be receiving confidential information from the company. So these confidentiality agreements typically include two major provisions. The first is the confidentiality provision, of course, which protects the confidential information of the company. And the second is, typically these also have an invention rights assignment language in it that just any invention that's developed while a service provider is providing services to the company gets assigned to the company. And like Patrice said, investors always ask about this prior to investing. So they'll ask, did everybody, all the consultants, all the service providers, all the employees sign a confidentiality agreement, and did they assign the rights to any inventions over? So as Patrice mentioned, it's a lot easier to do it upfront than it is to go back and try to get all those signatures. So it's just a good practice from the get-go to start getting those signatures. The other provision you might sometimes see in a confidentiality agreement is a non-competition clause if the consultant is particularly is heavily involved with the business. So I'd say it's rare that we see them, but sometimes if they provide services on a daily basis to the company will want to ask for a non-competition clause.
All right, capitalization. So here, when someone says they want to see your cap table, really what they want to see is all the issued shares of stock that you have outstanding at the moment, plus all shares that you have promised to issue in the future. Now, a promise to issue in the future could come in the form of an option or a warrant. It could come in the form of some other sort of agreement, or it could be in pursuant to a SAFE or a convertible note. So when you are showing an investor your cap table, you really want to make sure that it creates the full picture of your company on a fully diluted basis, meaning the issued stock that you have plus everything that you've agreed to issue in the future. I think it's also important for establishing trust with the investors you're working with that be very accurate. If you give someone a cap table, and then later on they find out that you've got some other warrants that you never, disclosed to them, it could breed distrust between the parties. So I like to make sure that that you're prepared to present a very accurate capitalization table. The other thing that I think is really, really important, and that is for tax purposes, that you issue stock to your founders, sometimes we call founder stock, prior to beginning the fundraising process. Now, the reason for that is important because your founders could, if you get backwards on that and you don't get your stock issued at the proper time and you issue it like right before you're doing the financing, there could be tax implications on your founders or on your entrepreneurs, whoever are starting the company, which you don't want to have. So really, it makes a lot of sense to take a look at your cap table prior to starting your fundraising process and make sure that everything's in order, that that any stock that should be issued has been issued, and that it's all accounted for on your capitalization table.
Lisa, when you're looking at the capitalization of a company, is there anything in particular that you're looking for, trying to avoid?
I'm sorry, were you asking a question, Kathryn?
Yeah, I was just asking if as an investor, when you're looking at a capitalization table of a company, is there anything in particular you're looking for or looking to avoid?
That looks great. You've covered it well. Thank you.
Sure. All right. So the next thing is getting your slide deck ready to present to investors. So what you should include, so at a minimum, you should include the problem you're trying to solve, the solution to the problem, which is usually your device or product or service that you're offering, the market potential for your product. So investors are looking to make sure that the market is large and growing. You'll want to show your management team, and it's fine if there are holes still to be filled in that management team, but investors typically like to even just see who you're planning on, what roles you're looking to fill. You want to show the competition in the marketplace. So it's good to have some competition because it validates that there's actually a market for your product. But of course, you want to show how your product is different and how you're differentiated in that market. Investors will want to see financial projections. So they'll want to see in the short term, in the next 3 to 5 years, maybe even shorter, what the company's goals are, but then also the long term, when the investor can expect to have an exit event. And finally, of course, you'll want to include what funds are being requested and how you're going to use those proceeds. What you want to leave out is anything that's too technical or confidential. So we usually don't recommend that, when you present a slide deck to an investor, that you ask them to sign a non-disclosure agreement, because it kind of sets sets the relationship off on the wrong foot. Of course, there's exceptions to that rule, but as a general idea, you want to try to keep out anything that's too confidential. And you know, later on, if you get down the road with an investor and they want to know more of that information, you can work on providing that. And finally, know that there's a lot of resources out there that can help with your slide deck. So whether that's, you know, people in your network or other companies that you can ask to review it and give their input. There's even consultants that their sole job is to look at these slide decks and to improve them. Of course, your attorneys can do that. So there's a lot of resources, and we highly recommend, you know, you have a lot of people look at your slide deck before you finalize it. Lisa, from an investor perspective, when you're reviewing slide decks, is there anything in particular you're really looking out for, or, you know, that in particular turns you off from a company?
Well, I think you hit on the highlights for sure, Kathryn. One thing I'm not sure if it was included or not, just to give it a little more depth, would be if you could include what's proprietary, if there's a moat around what it is that you do, not you know, speaking to anything that would be confidential or saying what's proprietary, but enough information that would give the investor some sense that there's something unique here. I mean, one thing might be, you know, first mover advantage, but if it relates to the product itself, that might be something to, you know, provide enough information so the investor has some understanding of what's unique. And then you touched on it too, looking at what is it that the entrepreneur wants as an exit, and is there alignment between what the entrepreneur is wanting and what likely the investor might want? Because you kind of have to look at the whole continuum. And one thing too, just because this is, you know, Twin Cities Startup Week, just to touch on, you know, really it all starts with the entrepreneur. If it's not, if it weren't for you, there would not be an opportunity. But if you look at the whole continuum of fundraising, I'm sure we have so many savvy founders in the Twin Cities market, but I know some entrepreneurs have done really well with non-dilutive funding. Some of the competitions, including MinCup and NIDA, some companies companies have gotten significant funding, non-dilutive funding, because of their participation in that, which is fantastic. And then you can look at SBIR, S through NIH, NSA. There are just a lot of possible alternatives too. And then you're going to go from that to potentially the angel market. You've got individual angels and you have angel funds. Go for Angels is the dominant angel fund in the Twin Cities, or very dominant. They've invested over $15 million in 50 companies. And then we've got Mighty, you know, Go for Angels, Sophia Fund, Capita 3. You've got Matchstick, Great North Labs, Bread and Butter Ventures, and then going further up the stream. So a lot of groups want to see customer traction, that kind of thing, but Groove Capital is looking at earlier opportunities. So the reason I'm bringing it up is one of the things that can help you is kind of understand what the opportunities are with these different groups, and then see which groups might be a best match for you and what you want. And then one other point too would be with regards to availing yourselves with accelerators, groups like Connect Up, Lunar Startup. There are just, you know, like Kathryn was saying, there's so many wonderful resources in the Twin Cities community to avail yourselves of.
Great, thanks, Lisa.
All right, so next we're going to turn to term sheet terms and kind of talking about what they mean and what you should be aware of for those. I mean, I think it's really important to understand what is being meant by all the terms that you might find in a term sheet. And also, you know, understanding that, you know, not every term sheet will contain every term that we're talking about here, but just to kind of have an basic understanding of all the possibilities out there, I think is really helpful to the entrepreneur. The terms that we're going to be going through are taken from the National Venture Capital Association form term sheet, so they're fairly standard terms. But that being the case, you know, with any deal, you can have differences or nuances that might not be exactly as we're explaining here. But if you understand what we're going to be talking about, then I think you'll be at a really, you'll get a good advantage for understanding what your terms will be. Before we start talking about that, before we start talking about that, I want to just go over one thing, and that is the idea of the investor you choose and the partnership that kind of is developed between the company and the investors. And when I say partnership, I don't mean that in the legal sense, but in the relationship sense. You know, in addition to providing funding, investors can really provide a lot of other benefits to a company. You know, they can provide advice, they can provide contacts, they can provide access to people and things that, you know, an entrepreneur may not know about or may not have any ins for. So I think that's, you know, when Lisa talked about a fit between investors, I think that's something that the founder entrepreneur should look at, is that, you know, what other things other than money can an investor bring that will help the company you know, progress and get to its next milestone and so on and so forth. Lisa, do you want to talk a little bit about, you know, the kinds of extra, you know, benefits that an investor can bring to a company?
You know, when you have an expanded network, you can help with customer introductions or possibilities there. I know one of our portfolio companies that worked out well. And then two, other investors. Typically, you know, we'd like to think that we could be one and done on a funding and get a company cash flow positive, and then, you know, they've got enough internal growth to be able to move to an exit, but that's not likely. And so we also can help convey opportunities to others that might be like-minded in what they're looking for in a prospective investment.
That's great. Yeah, and so I think an entrepreneur should always keep in mind that while you're, you know, pursuing investors, you know, you also are kind of interviewing them too to find out what kind of value they can bring to you. All right, so then speaking of value, the next
Right.
slide is on valuation, and I want to talk about two things here. One is just the nuts and bolts of how, you know, valuation and price per share is determined. But before that, I want to talk about, you know, who determines valuation. So the answer to that is it depends. If you're having a friends and family round or an angel round, it's very likely that the company will set forth or will give a suggestion of what its valuation should be. Now that suggestion is subject to what the market feels about it. So you have to be careful in making where you think your valuation is and setting that forth. If you're if on the other hand you are looking at venture capital money, it's more likely that a venture capitalist will say, listen to what you think about valuation, but they will present their own valuation based off their own metrics and analysis that they've done. So keep that in mind, in that the company, you know, may be setting valuation, but may not be. If you are, if it is an early financing and you are setting valuation, we want to stress that you should be very reasonable about what you're setting it at. You know, obviously everyone would like to have a high valuation, but if you come up with a valuation that's too high and that's not in line with your exit capabilities or, you know, your market share for your product, you either, you know, you most likely won't find any interest in the investors out there, or you could be, you know, in a problem where you raise money at too high a valuation and then the next round you do is going to have to be a down round, which nobody wants. So, so just really have an eye towards being realistic when setting valuation. Lisa, I really love your point of view here as well.
I'm sorry, Patrice, you cut out. Could you, I know you're trying to ask a question.
Yeah, great. So Lisa, what I was hoping is that you could give your point of view as an investor of what you see as far as valuation, how you view a company's valuation, and how you analyze what they think their valuation should be. Right.
Well, it is a very important component to the whole opportunity. You know, like you said, Patrice, you know, it's a balance between, you know, it can't be valued too low. We certainly all want to have the founding team to do well at an exit, but if it's too high, because many times entrepreneur of over optimism, and I'm guilty myself. I have it as well, especially as an entrepreneur. And you think maybe you'll get to your milestones more quickly than you thought, and that you would do it for less money. But I have to tell you that one of the companies that I participated in as a co-founder is a company called Stratasys in the 3D printing field. And we honestly thought that we would be able to get to cash flow positive on a $90,000. And it ended up taking us maybe $30 million to get to a commercially viable product. So, you know, we were just a wee bit off on what we needed to do. So we had multiple rounds ourselves. And so the valuation changed too. So that's a very key issue, the valuation. One thing that might be helpful, a couple things. One, Angel Capital Association has if you go to their website, they including information on valuation ways of doing valuation. And then providing some sense of objectivity. The Center for Venture Research, their 2019 report came out, and the average angel deal in 2019 was around $375,000. And the deal valuation was at $4 million. And last year it was just in 2018, it was a little bit under that. We are seeing a wider span, especially if you look at another, the Angel Founders Group report had a wider span for valuation from, I think, 2.5 for seed stage up to 8 million. So, you know, it can be pretty varied. The other thing I should mention is, and I didn't fully appreciate this when I was a founder, is if a company or if a angel group has 10 portfolio companies or an angel investor has 10 portfolio companies, the longitudinal studies show that only 7 to 11% of the investments are going to give you the return for the fund. So 5, you'll have less than principal, some going under, and then you'll have singles and doubles. But that's why we look at it, I look at it, I have to hope that there's a return on investment potential opportunity of 10x, because the opportunities that didn't go as expected. So I don't know if that's helpful to the whole discussion on valuation.
Oh, I think that's very, very helpful. And I think, you know, for an entrepreneur, they really need to understand the perspective of the investor when they're entering this process. And I think that that's really, you know, priceless as far as that's concerned. So, all right, then moving on as far as what how you get to the nuts and bolts of if you have a purchase price, if you have a pre-money valuation, what's your purchase price? That's actually a pretty simple calculation that I like to run through with folks so that they understand how to do it. So what you do is you take your agreed upon pre-money valuation and you divide it by your outstanding capitalization on a fully diluted basis as of the time of the financing, plus any increase that you're going to make to the option pool after the financing. When I say after the financing, I mean right after the financing, I mean as a term of the financing. And so realize that, if you increase the option pool, that's dilutive on the investors. So usually the investors want to see an increase to the option pool prior to their investment in order to allow the company to go forward and issue adequate options for the next 12 to 18-month period. So realize that that goes into the price and into the calculation. And then on the screen, I have a very, very simple example of what I just said with very just round numbers so that everyone can understand it. But if you had, let's say, a pre-money valuation of 10 million, and again, just using round numbers, and if you had 5 million outstanding shares on a fully diluted basis, and you were increasing your option pool by 500,000 shares, it would be 10 million divided by 5.5 million, and that would get you at $1.82 per share. So I think it's helpful to understand how these numbers are calculated on a term sheet, and then once you do it a few times, you'll understand that too, and are able to appropriately evaluate when you're discussing a pre-money valuation.
Great. So the next provision that you'll always see in a term sheet is the closing date. So this one's pretty basic, but it just gives the date the parties intend to close the transaction. The closing provision can be a single closing, or it can be a multiple, a tranche closing over multiple dates. Sometimes those are tied to the achievement of milestones. So for example, it'll be, let's just say, 50 million from the investors will be received on the closing date, and then the next 50 million is conditioned upon the company, achieving, let's say, FDA approval of their device or something like that. So more and more we're seeing tranche closings. When you're negotiating what the closing date is going to be, you want to make sure that the company isn't going to run out of money prior to the achievement of the next milestone. So you want to be, you obviously don't want to give too much time, but you want to give yourself plenty of time with a cushion that in case, it takes more money to get to that milestone, you factored that in. Additionally, when you're setting the initial closing, we usually see at least a month out. It takes time to for the investors to do their diligence, for the company to do all the drafting of the documents, to resolve any issues, to collect signatures. So usually that process at least is about a month. And Lisa, do you see any, or have you been seeing more tranche closings in your experience?
We have, Kathryn. We're starting to see that more. And the other thing that I mentioned too is that we're seeing pause because we want to see a minimum amount at closing, so we know the company has enough runway to get to the milestones that they need, just in case they do have some hiccups. And of course, we know the unfortunate challenges from COVID, and a lot of our portfolio companies got on it quickly to, let investors know that, they needed some breathing room. So, it's important to have a minimum amount closed if you do multiple closings from our point of view.
Sure, thanks.
All right, board composition. So this, I think, is really important to a company to consider. An entrepreneur may not realize this, but it really is the board of directors that sets the strategic approach of the company. It's the board of directors that really has to buy into any major actions that the company is taking, and it has to approve any major transactions that the company is entering into. So it's really important to have a board in place where every member is important and that they all bring something to the table that's important to the company at the stage it's at. Generally speaking, if an investor is making a significant investment in a company, they will expect a board seat or maybe a couple of board seats depending on the amount. And if you have a couple of investors making significant investments, they would each probably want a board seat. That's something that you have to go into considering when you're raising funds. That being the case, if you have somebody making, if you have a bunch of people making a more minor investment, then it would not be reasonable to give all those folks a board seat. So it's an important role. And so you want to make sure that it's filled by folks who, where it makes sense for them to have a board seat and also that they have things to offer. Another thing I see in companies is they might start out with too big of a board. So they might end up having, 5, 6, 7 people on a board, and generally investors will frown on that. For a startup company, having 2 or 3 directors, I think, is probably more appropriate. So keep that in mind as you're setting your board. Also, really think about where you're at as a company, what your next challenges are, and who you need to be able to advise you to get through those next challenges. And that's where we talked a little bit before, where investors can come into play. Lisa, can you talk a little bit about how you view board of directors and size, and who should be, what types of folks or expertise you expect to see on a board of directors?
Kathryn, your question cut out, but I think I got the gist of it. In terms of what we see, we typically see a smaller board when they come to seek an investment from Sophia Fund. So a 3-person board, usually that's comprised of the founder, who usually is representing the common stockholders as well. And then typically we come in on a preferred round, so there's a representative for the preferred. And then there might be someone with domain expertise, or another domain expertise, or maybe there's another founder. And then things change once you go out for like a Series A round, then the board gets expanded, like you say. And if there are too many insiders, then that changes as well, the makeup of the board. But frankly, we just got an opportunity, and this was through another angel group, and it's a tech company that was seeking capital, and they had no board, and we're kind of going, no, that's not going to work. For maybe individual angels, they might be comfortable with that, but for a managed fund, that wouldn't be possible. And so we conveyed that to them, and they said, well, we were going to do it when we got our Series A round financing going. And we're saying, well, if you're interested in us, we need to see a board. So and in fact, that hasn't, they did change that. And so now they have a board that's in process. But I think PM, then you need to realize that there is a governance structure that needs to happen at that point.
That's great advice, and I think that's exactly what we're trying to, in a sense, teach here, is that to be prepared means you have to have these things in place before you start a financing.
So the next provision that you'll see in a term sheet is dividends, and we can do this one pretty quickly. It's not typically a very negotiated point in the term sheet, but dividends are simply just the company distributing its profit to its shareholders in the form of a distribution. Typically for early stage companies, there is not, they don't declare a dividend because, and first of all, they might not have any profits yet because they haven't sold their device or their service, but even if they do have some profits, oftentimes those will get reinvested back into the company. So like I said, this isn't typically a very negotiated point. We've on this slide included 3 alternatives of how this provision usually presents itself. We typically see term sheets including the 3rd alternative, which is just that that dividends will be declared or will be paid when and if declared by the board. So it's pretty rare, but they have that in there.
Yeah, at liquidation preference, again, I'll just more or less explain how it works, but there again, it tends to be a certain way. So liquidation preference you think of as being the downside protection for preferred stock. So what that means is that if you're going to have an exit of the company, either because the company is dissolved or sold or anything like that, then the preferred stock get their money back first. And after the preferred stock get their money back, then the rest of any money left over, if there is any, would be distributed among the common stockholders. So that gives the investors who are investing in preferred stock the knowledge that they'll be the first money out if things don't go well. That being the case, nobody wants that. Everybody wants a situation where you have a big return and then the preferred stockholders say, instead of taking my preference, I'm going to convert to common stock and we take my return with all the other common stockholders. And that's really the result that everybody wants. One of the alternatives here is called a participating preferred. You usually don't see that in a Series A financing, but you should be aware of what it is. And that means that the preferred stockholder gets their money back, and then they also participate with the common stock on any additional funds that are distributed. So it's a very positive term for the investors and not positive for the common stockholders. So it's certainly something that you would probably only agree to if you lack some leverage in the deal. And just to reiterate, the most common situation is a 1x return where the preferred stockholders get 1x and the common stock gets the rest. That's the most common for an early financing.
So protective provisions, these are really common in a term sheet. Basically, they're just saying that a certain a class of stock will have veto rights over certain corporate actions. So as you can see on this slide, I think it carries over to this next slide. These actions usually include things like liquidating the company, merging with another company, creating a new class of stock, declaring dividends, increasing the size of the board, etc. Those are all pretty common things that we see. There's some that are more controversial. We don't see them as often, but an attorney that's helping you with the transaction would be able to point out the ones that are typical and which ones are atypical and shouldn't be agreed to. And the main thing that we're looking for with these protective provisions, like I said, they're very typical. Usually investors always get them, but we do want to make sure that the voting thresholds are set up such that no one investor has a block over any particular corporate action. So, a whole group of investors might be able to block an action, but we don't want any one investor to have so much control that they can make all the decisions for the company.
All right, anti-dilution. So just a primer on what that is. What that is protection for a preferred investor if future sales of stock are sold for less than the purchase price that the preferred investor purchased their stock for. So it basically allows them to shift the dilution of that next financing from them to the other stockholders of the company who would typically be common stockholders. They're the most common anti-dilution provision is what's called a weighted average anti-dilution provision, and that's this definition that's on the page right now. That basically spreads the dilution among all shareholders, but it spreads more of it to the common stock than it does to the preferred stock. Versus a full ratchet, which would basically means that the preferred stockholder is not diluted at all, and all of the dilution comes to the common stockholders, which is obviously not preferable for a founder or an entrepreneur, and usually something that you want to be very careful before you agree to. And then finally, the third would be no anti-dilution protection. Again, that's not very common as either. So mostly you're going to be in a situation where you're agreeing to weighted average anti-dilution protection.
So another term that's very common in term sheets is a drag-along right. So basically this just says that a certain percentage of the stockholders can force the other investors and founders to go along with a sale or a deemed liquidation event of the company. So essentially the rest, if a certain percentage agrees to enter into, a sale of the company, all the other members are dragged the transaction as well. And like I said, this is very common, but the two options that founders sometimes have to limit the control of the drag or the effect of the drag along They can, negotiate where the trigger threshold is. So is it 50% of the stockholders can force this? Does it have to be 75%? So there's some negotiating room there. And then additionally, in early stage financings, you can sometimes request a separate common vote to trigger the drag along. So, and usually the common stock is held by the founders. So that gives them a little bit of leverage in early stage financings.
All right, registration rights. So these are an agreement by the company to register the shares of stock held by investors after a period of time, and usually it's a period of 5 to 7 years. And the purpose of this is to give, if the company hasn't been sold, to give the investor liquidity and the ability to sell their shares on a, they can take a return off their investment. So this goes back to things that Lisa has talked about before about how an investor will look at and have an idea of what their return, rate of return will be, and want to be able to get a certain rate of return based off the number of years that they've held the investment. So this is certainly having to register or doing an IPO would be very, very, very uncommon for a startup company. You generally need to have very high revenues for you to be considered for an IPO process. So it's usually not something that really matters that much to a startup company, but it may still be in your term sheet.
So preemptive rights are, in this provision, it just entitles investors with the right but not the obligation to purchase the number of shares in a next round financing that for them to maintain their current percentage ownership of the company before other investors are allowed to purchase shares. So it's a pretty important right. Most major investors will ask for these, so not necessarily, you don't, a lot of times companies don't have to give this to all the investors, but all the large significant investors will ask for it. And they're important just because investors want to guarantee that they're going to be able to maintain their ownership percentage for later rounds. But additionally, some of the rights that they might be given in earlier rounds might be conditioned on maintaining a certain ownership percentage. So it's important for those investors to know that they'll always maintain those rights.
Yes, Lisa, go ahead.
I just add, Kathryn, that they want all of their shareholders to participate because they need the investment. So, when we see companies, that's something that is important just to bring funds into the company. And then also, I would just say that as they try and seek other investors, it gives credibility if you have most of the current investors continue to participate in investing in the company.
Right,
Agreed.
definitely.
Showing that they still believe in the company, which is important. So.
Exactly, yeah.
All right, right of first refusal and co-sale. So this is mostly a provision that's put in to protect investors from having a founder take an early exit and walk away from the company. So it's a provision that it's fairly common that would say that your main founders will have to agree that if they want to sell their stock in the company, that they need to first offer it to the company to repurchase and then offer it to the investors. And if they have a very good price for their stock, they need to allow the investors to sell their stock in place of the founder's stock. So it's really just a protection provision. It rarely ever comes into play, but it is something that would protect an investor from having a founder exit and take a return without allowing the investor to take a return.
This is an example of a no-shop clause that you see in term sheets. Basically, all this you won't talk to other investors for a certain amount of time after signing the term sheet, and that just gives the lead investor the opportunity to do their diligence and work with the company to come up with a definitive agreement. Usually we see about 30 days is a pretty, give or take, is a pretty typical amount of time for a no-shop clause. usually in term sheets, this will be the only term that's binding. So all the other ones, you know, give the intent of the parties, and they're certainly important. And during the deal, we always come back to here's what the parties agreed to in the term sheet, but none of them are technically binding. But this one, you know, we typically do see that this one's binding on the company.
All right, our takeaways. So our takeaways are, you know, I think a pretty good summarizing what we've been talking about and fairly simple. We want to make sure that your house is in order, that you're ready for going to do your fundraising, that you've got all your I's dotted and your T's crossed, and have done all the things that you should have done prior to raising funds. You want to make sure that you understand the financing terms and that you are clear on, you know, where you stand and the things you want to get out of the financing, and make sure that you are able to get those things. You want to plan for success because you're all going to be optimistic, but you also have to understand that it takes longer. We were talking about this in our planning session, and you know, I think my estimation is that it probably takes 2.5 times as long as you think it's going to take to get a financing done. So always keep that into consideration. Keep optimistic during that process, though, because you know these things happen, but it just takes a lot longer than you normally would have thought. And then, as Lisa kind of said, the entrepreneur is key to starting the ball rolling. You know, it's the entrepreneur that sells the company. It's the entrepreneur that brings the spark to the company, and it's the entrepreneur that makes the investor think I've got to be part of this company. So always remember that, you know, that you're really key to your own company. Anything else, Lisa? Is there any parting words that you would like to say?
Well, I just would reiterate, you know, what unfortunately so many of our companies have experienced is there are outside variables that can really cause great stress to a company, like COVID. And you know, when you do plan your financing, be sure and give yourself enough buffer. One of the things that we've seen is, you know, like you're saying, Patrice, it takes longer than you expect, and you need to have a lot of different prospects going at the same time, because you never know at what point they're going to say, hey, you know, we found out that this is not going to be a match because of X, Y, or Z. So you don't want to be, you have enough stresses as a founder as it is, both positive stresses and negative ones, and you don't want to be you know, worried about making payroll because you're so tight on funds. One other thing I would just share is study that last came out, that overall the yield rate for entrepreneurs seeking angel capital is about 1 in 3, about 30% yield. But we still have work to do as it relates to minority and women entrepreneurs. And I'll be a little wonky here and give you some stats. For minority entrepreneurs who presented seeking capital, of that whole entrepreneur, the yield was 28.2%. And then for women, entrepreneurs seeking angel lending were made up 27.6% of that, and 21.4% received capital. So we still have work to do to continue doing things like Twin Cities Startup Week, Meeta, Lunar Startups, Connect Up, all the great programs and resources in our community to help increase the total pool of entrepreneurs. That's what I would just like to share.
Thanks so much. That's perfect. So, Kathryn, anything you want?
No, I think we can probably open it up to questions.
All right. So we're going to move to the Q&A session, but thank you guys all for attending this session, and we really enjoyed providing the information to you, and hopefully we'll talk more in the Q&A. Thank you.
Thank you.